So again, consideration is simply something exchanged, whether that's you doing something or refraining from doing something to entice whatever the other person's offering to do for you. Something that you're bargaining with that you weren't otherwise legally obligated to bargain with. Now, this can be distinguished from a simple gift, which is what I was referencing with somebody just offering to do you a favor and say, "Oh, I'm going to mow your lawn when you are away," and you say, "Okay," but you don't really offer anything to entice them to do that. You don't say, "Well, if you do that, I'll wash your car," or "If you do that, I'll give you $20," like in the second scenario I discussed. A simple gift we don't usually hold people to under a breach of contract theory because of this lack of consideration between the two parties, this lack of bargaining for something that they had to trade. Now, there are situations where somebody could offer to do something for you and you didn't, the other party didn't entice the person with anything that they had to bargain with. And so we may have an offer and acceptance, but we may be lacking consideration, and thus we can't consider it a contract, and you can't find a remedy on a breach of contract theory. There are situations, as you can imagine, where somebody has made a promise to do something, even though the other party didn't entice that promise with any consideration. But it would, under the circumstances, it would be unjust and unfair to let them go back on that promise. And that's mostly because, or namely because, sometimes we may be, even though we did not offer anything in exchange for the promise, we may have done some things in reliance on that promise to our detriment. So, because you trust that person's word under the circumstances, and you have reason to, you may go out of your way to make some moves in reliance on that promise, expending some money, changing some things about your situation that you weren't otherwise going to do. And you didn't use those things to entice the promise, but you did it in reliance on the promise, and it may be reasonable that you did. And so in those situations, we may not have a breach of contract remedy, but we may have another remedy called a promissory estoppel. Before I move on to that, I just realized I skipped over something, which is was clear about the definition of consideration. What I didn't point out is that because consideration simply is something that you have to bargain with, that's really all it is. It's not a question of how valuable it is objectively, because we want people to have the freedom to contract, and what's a good deal for you may not be a good deal for me. And so, as a general rule, courts aren't going to inquire into the adequacy of consideration. In other words, if you want to trade $1 for something that to most of us would be worth $500 or $1,000, if that is what it is worth to you and that's what it is worth to them, you're both trading something that you weren't otherwise legally obligated to do. And so courts won't question whether or not you got a fair deal generally. That's kind of up to you, and to have the freedom to, again, make a decision that may not be a good deal for me, but we want you to be able to decide for yourselves what makes sense in your situation and whatever you want to exchange in exchange for, or whatever the parties want to exchange that makes sense to them in their situation. So I said that $1 might be enough if we're talking about cash, but there's a famous case that's taught in law school where the judge says the adequacy is so unimportant that it'll be something as small as a peppercorn. If you weren't otherwise obligated to trade your peppercorn, if that's what you wanted to trade, then that may very well be sufficient consideration to consider that we have a contract. But now back to promissory estoppel. This is a situation where we don't have a contract, where it does not appear that the parties have both exchanged something, and thus we're lacking consideration. Now, this is about reasonable reliance on someone's word, on their promise to do something, when even though you didn't offer anything in exchange for it. So the case in the book on this point that I think is a good illustration of how this situation can happen is called Henson versus N&W Construction Company. It's from the Court of Appeals of Mississippi from the year 2004. So a little background here. Basically, we have a general contractor who's looking to bid on a large construction project, and as part of that process, he needs to kind of size up the other subcontractors that he's going to need for things like the plumbing throughout the building, the roofing, maybe different elements that maybe he can't, his company can't do by themselves. So they take a part of what the money they're expecting to get for the whole project, and they try to find people that they can pay with that money to do these individual complete these constituent parts of the entire project, such as the plumbing within the whole building. And that's what this case is about. It's about a company that the general contractor seeks to have do the plumbing. And so before they put a bid on the property, they're going to go around trying to find the cheapest price that people can do this. The cheaper they can do it, the cheaper, say, a plumber can do, or a plumbing company can do the plumbing, the more money the general contractor stands, of course, to collect from the overall project. And so as part of this preparation, the general contractor here is called N&W Construction, and they prepared a bid for the construction project, which was the Mississippi Job Corps Center, to build a kitchen facility at their training center. And in preparing the bid, they talk to several plumbers, and they find the lowest one they can get as is Henson, who is the company appealing the lower court's decision, which was in favor of the construction company. And Henson quoted $92,000 for the whole job. Now this was about this is about $47,000 less than the next cheapest plumber. So N&W Construction Company, this is very appealing, obviously, because this means he stands to make, at the end of the day, an extra $47,000 on the total project. And so he chooses, not surprisingly, Henson to do the job for $92,000. Now, they never really sat down and formalized their contract. And basically what we have here in this situation is where Henson has made a promise that he could do the work for that price, and in reliance on that, without completing the deal with Henson, N&W Construction then uses that, along with some other bids for the other work, to place their total bid on the total construction project for the kitchen facility. When he wins the bid, based partially on the fact that he got this great plumbing deal and was able to outbid everybody because of that, I'm sure, he goes back to Henson when he's now bound himself to the Job Corps Center to do their kitchen. He goes back to Henson, and Henson then refuses to do the job. He says, he changed his mind for no good reason, as we find out, and says, we never completed our contract. We never had a contract. We never set down the terms. And that's really what's at issue here, is that there's many terms to be worked out in an agreement like that, and they hadn't really discussed anything other than the fact that he could do it for this price. But none of the other terms have been worked out. So they don't have a contract. However, it goes to court, and N&W Construction ultimately prevails on this theory of promissory estoppel because there was reasonable reliance on the promise that they could do the work for this price. He relied on that, N&W Construction did, in determining what figure he was going to present when bidding on the overall general contracting job. And what's important here is that his reliance on that promise in making that decision is reasonable under the circumstances. And there was some testimony, I believe, that that, well, one, Henson really had no good reason to back out on his promise. He essentially just said he didn't feel like doing it, and when it came time to do the job, and also in this industry, this was the custom of general contractors to go around, and when they're asking for these bids, it was well understood by people who worked in this industry that somebody coming around asking you for a bid like that, even though you hadn't worked out the rest of the terms, was going to rely on that in placing the bid on these large construction projects. And so what's important isn't not just that N&W Construction was reasonable to rely, but that Henson should have reasonably known, they had every reason to know that what they were saying was very important and that it would be relied on when N&W Construction got ready to bid on this project. They knew that they were the kind of job they were preparing to do. Henson had reviewed the plans and had given, and it also testified that the amount he quoted was correct, and he could have done the job for that price, but just decided not to. And so this is a situation where, again, we don't have a contract, but it would be unfair and unreasonable to let somebody get away with making a promise because of what they know and what they should know about the other party and the position they're in. And we don't want people to be able to get away with making such loose promises when they have every reason to know that there's going to be a detriment to someone if they do not fulfill that promise. Now, when the book talks about capacity to contract, this means that you have a legal ability or not to enter into a contractual arrangement. Now, you have some idea of this already. You probably, or you may know that children generally can't enter into contracts with adults because they're minors. And in many situations, the law presumes that a minor below a certain age is not capable of making sound decisions about important topics, and so we presume that any indication of their consent is null because they are too young to understand what they're getting into. Well, but when we talk about capacity, generally we need to divide this into two different categories: contracts that are void because there's no capacity to contract, and contracts that are voidable. And this is an easy distinction to remember, but it's important that you remember this. A void contract is one that is simply treated as if it never existed. An avoidable contract you could also just call an avoidable contract, because that's really what it means. It means the contract can exist, but one of the parties has the ability to avoid it if the other party attempts to enforce it against them. So in the case of a minor, in void contracts, let me go back. A contract is going to be void where the situation is such that it could never be valid, where maybe the person will never have the capacity to contract, or the subject matter is illegal. And avoidable contracts occur where somebody may have lacked the capacity to contract for whatever reason, but there will come a time, or there might, when they will later have the capacity to contract. And at that point, we have a voidable contract. So in the case of a minor can enter into a contract if they're under the age of contractual consent. Then that contract cannot be enforced against the minor. But once the minor turns to be an adult at the age of 18, or whatever the age of consent might be, in the age to contract might be in a different jurisdiction, they now have the capacity to contract. And so that contract, they now have the option to avoid it if they want to, since they didn't have the capacity to begin with. But now that they have the capacity, they have the option to go through with it. And that's how a voidable contract works. There may be a time when you're maybe, in because of some mental illness or defect, you lack the capacity to contract because you're not in your right mind at the time. But then when you when you get over whatever the ailment is, then you may again be in a situation where you have a voidable contract, where you have the option as the person who didn't originally have consent to avoid it, but you can also ratify it if at the time that we're looking at the contract, you have consent at that time, or you have the capacity to contract.